The Supreme Court! It's the top of the layer, as in it's the most important, has the final say. The only federal court with original and appellate jurisdiction. There's nothing above it. It's supreme. You need love. I need love from the Supreme Court. I've already lost twice. This is it for me. But how do you get a case to the Supreme Court? So cool people call this Petition of Cert. In fact, I only hear people call it that because I only hang out with cool people. Dictionary.com says it's pronounced Petition of
Certiorari.
A petition of cert is when someone files a petition asking the Supreme Court to look at their case. Dear Supreme Court, I have been wronged. My civil liberties have been taken from me without just cause. And I believe if you look at the due process of the law, you will see I should be set free. How do these 9 justices decide if they want to hear this case or not? That's where the rule of 4 comes into play. The rule of 4 states that at least 4 of the justices have to agree they should hear a case. The Supreme Court will take like 150 out of 7,000 cases each year. So yeah, making the docket is tough. Alright, Girl v. Meenan, who thinks we should take this case? Yes, no. Yes, no. No, no. Yes, no. Yes. Ooh, that was a close one. The court will call for a writ of cert. A writ of cert is an order from the Supreme Court that a lower court must send up a case file. We, the Supreme Court, demand that the case file for Girl v. Meenan be submitted immediately. In the next step of the process, both parties will submit briefs. A brief is a written document that explains why the court should rule in favor of one party. In the Supreme Court, there are law clerks. They work for the justices. They look at the briefs, they see if they're constitutional, they see how they relate to laws, they look for precedent from other cases, they look how it could affect the nation, and they report all this to the justices to keep them informed. I heard the briefs for Girl v. Meenan were like really bad. I can't believe they didn't hire some lawyers that could actually write. The justices will give each side about 30 minutes to make their case, and they're supposed to save some time so they can answer the justices' questions. What do you have to say, Girl? Ew, he's boring and gross. He's ill, Your Honor. And he kidnapped my soul, and I'm worried about everyone else's soul, and he has to be stopped. He's ill. What do you have to say for yourself, Meenan? It's not against the law to be boring. I'm physically incapable of kidnapping a soul. And I just want to say thank you for your time, Your Honors. You're very supremely great. Conference and vote. The justices will sit around, talk about the case, how it correlates to the Constitution, what effect this would have on the nation, and then they vote. The justices do not all have to agree, and a lot of times they don't. You need a majority, which if all 9 are presiding, 5 out of 9. Then they write their opinions. A per curiam opinion is a brief, unsigned court opinion. The court sends someone outside the steps of the courthouse and they alert all the protesters and all the media the outcome of the case. The majority opinion is the official opinion of the court. So 4 justices can think you're crazy, but as long as 5 agree with you, you good. The concurring opinion is when the justice writes why they agree with the outcome, but for different reasoning. You might wonder, why write something up if I agree with the court? Because they use these as precedent. You could influence future court decisions, and you've got this great reasoning that they didn't put in the majority opinion. You gotta write it up. Justices do not always agree. A dissenting opinion is when the justice writes why they personally disagree with the majority opinion. Dissenting opinions can be used in future court cases. Plessy v. Ferguson upheld segregation, but their dissenting opinions of justices that didn't agree with the outcome were used when they fought for civil rights later. In the case of Girl v. Meenan, a majority opinion has been reached. Oh my gosh, I'm so nervous. Am I the only one who's nervous? You are not guilty for... Yes, I knew it! Awesome! Excuse me, I wasn't done talking. You're guilty of treason. Oh. I guess this is goodbye. Forever. Doc! Marty! There you guys are. I've been running all over Hill Valley looking for you. I need to borrow the DeLorean. I have to go back in time and make my videos funnier.
Great Scott! That's scientifically impossible. They're absolutely amazing as is.
Oh yeah, good point.